Hello and welcome to the Candidate for Cameron Law Office Legal Podcast. In this edition, we look at defenses to the charge of refusal to take the breath test. Now, in most states, the purpose of the refusal statute is to encourage all suspected drunk drivers to take the breathalyzer test or whatever breath test is involved. In New Jersey, the refusal statute provides that a driver shall be deemed to have given his consent for the taking of samples of his breath for the purposes of making chemical tests to determine the content of alcohol in the blood, provided that the taking of the samples is made in accordance with the provisions of this act and at the request of the police officer who has, quote, reasonable grounds to believe that such a person has been operating a motor vehicle in violation of the provisions of the statute. At a trial, the municipal court must determine and the state must prove that the arresting officer had probable cause to believe the person had been drinking, had been driving, and was under the influence of an intoxicating liquor or a narcotic. The state now must prove all these elements beyond a reasonable doubt. Let's see. Oftentimes, the issue is whether or not the person refused to submit the test upon the requested officer or whether the request for samples was made pursuant to the law. Now, in New Jersey, the Act requires a standard statement prepared by the director, that means Director of Motor Vehicles Commission, shall be read by the police officer to the person under arrest. This statement by statute mandates the police officer shall inform the person of their rights of the following, including, quote, a record of the taking of such a sample, disclosing the date and time thereof, as well as the result of any chemical test, shall be made a copy thereof upon request be furnished or made available to the person so tested. In New Jersey, the police are required to read a standard statement. They can't deviate it. They have to read basically from it word for word. Let's see. In New Jersey, in addition to the samples taken and tested made at the discretion of the police officer, a person tested is permitted to have a sample taken of their own breath, urine, or blood by a person or physician of their own selection. It's often difficult at night to get that done, but that's one of their rights. And under the statute, the police officer shall inform the person arrested of the consequences of refusing to submit to the test. If the police officer does not advise the person of the consequences of refusing, that could possibly be a defense to the refusal charge. The plain language of most statutes requires not merely reading the information in English to the arrested person. Rather, the person should be informed in a meaningful way so the person can make a knowing, intelligent choice about submitting to breath samples. The Supreme Court of New Jersey has even recognized confusion doctrine in State versus Leavitt, spelled Leavitt, 107 N.J.A 554. Now, ordinarily anything other than an unequivocal consent to taking the test is a refusal. However, the New Jersey Supreme Court last year in the landmark case of State versus Chun held that quote, zealousness in ridding our roads of drunk drivers cannot overcome our ordinary notions of fairness to those accused of these offenses. And from time to time, courts must re-examine much of our earlier jurisprudence as part of our consideration of the issues raised. And one issue is where someone either does not understand the test because English is not their first language, or because the person does not give a sufficient sample of air that's needed to work the new alcohol test. Now, in New Jersey, for the alcohol test, the Supreme Court in State versus Chun stated at page 28 that the operator is required to read the following instruction to the test subject. Quote, I want you to take a deep breath and blow into the mouthpiece with one long continuous breath. Continue to blow until I tell you to stop. Do you understand these instructions? Question mark. Possibly if the police officer fails to read these instructions, that could be a defense for refusal. The court also notes that in footnote 14, even if the officer types in the code on the alcohol test machine for refusal, he is not required to issue a summons for refusal. Instead, the officer may opt to start the test again and give the arrestee 11 more attempts. Alternatively, the officer may determine to terminate testing without charging the subject with refusal. An operator will generally select this option if he concludes the subject has in fact attempted to comply but is incapable of providing a sample that meets the minimum test criteria. Also, the Supreme Court of New Jersey said the operator must retain a copy of the alcohol influence report and give a copy to the arrestee. That typically means that day. So even if there's not sufficient air, when the printout is made of the alcohol influence report, a copy should be given to the suspect on the night of the arrest. For representation in the refusal to submit to DWI and breath tests, contact the Law Office of Kenneth McCammon, 732-572-0500, located at 2053 Woodbridge Avenue, Edison, New Jersey, 08817. You can also call us at 1-800-NJ-LAWS-7. That's 1-800-NJ-LAWS 7. We're on the web at www.njlaws.com. That's NJLAWS.com, or benotguilty.com. That's benotguilty.com. Thank you and good luck.